Welcome back. I'm Michael Short, and we're here with Doug Anders and Richard Sanders talking about military divorce. Now, what is a so-called military divorce versus a regular divorce?
Well, ultimately, a military divorce is just kind of what a name we put on it when there's a service member involved. When there's a soldier or someone in the Navy or something like that involved, we typically term it a military divorce. Now, there are no federal laws governing divorces. Each state can decide what laws they want to govern a divorce. So military divorce just means that there are certain military aspects that are required throughout the pendency of that divorce.
Now, since you could be a resident of one state and stationed in another state and only be there temporarily till you go to another country, how do you determine what jurisdiction do you get the divorce in?
Well, under the laws of Georgia, you either have to be a resident of the state of Georgia for 6 months, and the official word's domiciled, which is just a fancy legal word meaning resident with an intent to remain here or return, or stationed in a military installation here for 12 months or more. So if the soldier's here for 12 months or more, no matter where he's domiciled, then the state of Georgia says we can grant the divorce in Georgia.
Now, what if you're married to another military person and they've been relocated someplace else?
Sure, and that's when it gets really complicated, because you're starting to track down, all right, where did you live together as a marital unit? What is the best place to get that divorce? And ultimately, it's just a question that depends on facts and circumstances, because when you file the divorce, depending on what you're dividing, the court has to have jurisdiction over the marriage and jurisdiction over the person to divide up that property. So you just have to go back and track down and figure out where they live together, tell them to call an attorney there to figure out what the laws of that state are to determine if that's a better state or if Georgia's a better state.
And that's different between civilians in what way?
Well, because with civilians, you generally don't get multiple parties from different areas moving around as much. But it would be the same thing. I mean, if you have some sort of company to where you move around every 4 years or so, well, then it would be the same circumstances. There's no difference, except the law in Georgia is 12 months stationed at a military installation. So that 12-month rule is in place just for military members.
And that relates to the subject matter jurisdiction. Once the court has subject matter jurisdiction and you get personal jurisdiction over one party or the other, if one of the spouses moves away, there's continuing jurisdiction within that county where the marital home was for 6 months. All right?
Yeah.
Okay. And what if the soldier's deployed?
Well, it just generally depends on the soldier. If the soldier wants the divorce, well, then there's not going to be a problem. I'm representing a handful of soldiers that are deployed to Iraq, Afghanistan, all the way around the world. And if they're the ones that want the divorce, it's possible to get the divorce done without them ever having to come back here. Sending documents, having them sign the documents, submitting affidavits and stuff of that nature. Now the problem runs in if that service member who's deployed doesn't want the divorce. Because if you haven't initiated the divorce before that service member deployed, then the Service Members Civil Relief Act comes into play, which basically says that you can't proceed in an action without that member because they're overseas serving their country.
So if you go ahead and you don't fight the divorce, you get divorced, and this is a civilian you're divorcing, do they have a right to get into your military pay?
Sure, absolutely. And if you're a military member, you are required under whatever branch of service you are to provide support for your family. And your command will enforce that order. So until there's a civilian order in place, your military orders are going to require you to provide support for that family member, meaning your spouse. And what I commonly tell clients is there's two worlds in the divorce. There's the civilian world, which I can handle. There's the military world, which I can advise them on, and I can say, hey, here's what this regulation says, here's the interpretation, but you need to take this to your command. You need to say this to your command and let them explain. Because ultimately, he needs, and I say he because it's generally the man who's the service member, he needs to talk with his command and say, hey, here's what I'm doing, here's what my civilian counsel said, and make sure everything's on the up and up with his command.
And what if there are no children involved? Is there still support issues?
Absolutely. The military regulations just provide that you must support your family. Every branch of the service gets a basic allowance for housing generally, and that amount or an amount thereof goes to support the family. And so if a service member comes to me, there's no court order in place, and he says, hey, I'm leaving my wife, I don't have any kids, how much money do I need to give her? I say, well, in the civilian world, technically you don't owe her anything right now until there's a court order in place. But your command is going to require you to pay something. So as soon as you leave here, go sit down with your command, have them calculate the amount, tell you what you owe, and then we'll work on getting a court date and see if we need to adjust that number.
And generally it is, because you're married, you're going to get an extra amount in your paycheck because you're married. So that extra amount is there for your dependent. So if you don't pay that money over to the dependent or use it for their support, you're getting unjust enrichment. And the military, they can't order you to pay it to her directly, but they can take it back out of your paycheck because you haven't used it for its proper purpose.
So if you get divorced, you're still going to get the money?
Not at divorce.
Well, there's certain regulations, and if you don't have children, then absolutely you're going to then get BAH without dependents. However, there's certain regulations that if you have children, that you're living off post, and you're paying a certain amount of child support, then you will get BAH differential, and it gets fairly complicated, and you've got to look at the charts, and it makes it easier to explain with the charts. But if a service member comes to me, I usually say, hey, I'm not the one that pays you. You need to call DFAS, which is Defense Finance and Accounting Services. Right. They're the ones that cut the service members' checks. I say you call them, you get directly from their mouth what your pay is going to be when the divorce is over with.
Now, if you're in married housing and you get divorced, is she allowed to stay there?
No. Well, according to the military, no. As soon as you're divorced, she is going to need to clear quarters because she's no longer a military member's spouse. Now, what I have seen in the civilian world again is some judges will delay that order of divorce to give whoever's in the house time to gather her belongings, his belongings, and possessions, and make that transition to get out of that on-post housing.
So which law supersedes, the federal post with federal law or the state law?
Well, what happens is the state judge just kind of makes a stay in the proceedings because you've got to have the final order of divorce to take to your command and housing and say, hey, we're no longer married. She needs to get out. But what happens is that judge just delays signing the final order. So the service member can't take anything to his command because the civilian judge has not signed any order.
Well, and your eligibility to stay in quarters is based upon the marital status by statute and regulation. So if you no longer fit that criteria, they can't grant technically an exception to that. It's under the statute. So the judge, the civilian judge, as Richard said, can just delay signing the order and entering it to give the parties time to sort things out.
Okay. Well, thank you so much. We'll be back with Gene Brooks talking about accident reconstruction with special guest James Sloan right after this.